Good afternoon, class. My name is Dwayne Dixon, and this is my video forum 2, a case study. I actually chose the Texas Association of Counseling and Mental Health Services. There were several cases listed from A to Z. They went all the way from 2018 back 10 years to 1998. The good thing I can say is that there were very few cases that actually dealt with a breach of confidentiality. One of the most common complaints were basically procedural complaints, and they were dealing with either record keeping or supervisors not filling the appropriate forms, or interns not filling out the appropriate state required forms under the ACA. There was a failure to provide, quite a few with failure to provide clients with client records. But what surprised me was probably the most common complaint was unethical and unprofessional contact with clients, where counselors crossed over that line between a counselor client relationship, and there were quite a few, that it dealt with sexual misconduct. The one I chose to review, her name will remain anonymous, so I will call her Miss S. And she was an intern. She was a licensed practitioner intern at a juvenile facility. And in October of 2014, she received a young patient who was sent to her by the county. And she proceeded to counsel him for the next 8 months. June of the following year, that was in October of 2014. In June of the following year, he was released. Sometime after that, his mother had been reviewing his phone, and she saw that there was inappropriate text messages and pictures and naked photos of the counselor. So she immediately notified the county. The Texas Rangers got involved, and when they interviewed the young man, he said that the counselor had actually met him at a concert in a Rio Grande Valley, and they actually spent a couple of days together in a hotel. And he admitted to sexual conduct. It didn't increase into intercourse, but still, at 16 years old, of course, it's inappropriate not only for a counselor, but a child. It could be considered child abuse. So she was immediately charged with a second-degree felony, and she also was charged with indecency with a child by sexual conduct. Actually, she's still fighting those cases, but the position of the board, of course, they revoked her license September of 2018. It says that the complaint that the reason why they got rid of her license, it says she did not maintain professional boundaries, which is Section 22 of the Texas Association of Counseling, 681-41. 2 was sexual misconduct, Section 22 of the Texas Association of Counseling, 681-42. The third was failure to notify board of her arrest in a timely manner. That was Section 22 of the Texas Association of Counseling, 681.45. And the fourth one was the failure to respond to the board, which is Section 22 of the Texas Association of Counseling, 681-46. And I assume she did not respond to the board because she's currently still incarcerated. The next question was, what does the ACA Code of Ethics and your state code say about counseling impairment? Well, in the state of Oklahoma, Association of Board of Mental Health, Under subsection 1, 86 10-3-2F, it deals with impairment. And what it says that an LPC shall not offer or render professional services when such services may be impaired by a personal, physical, mental, or emotional condition. LPLC shall seek assistance for any such personal problems with their physical, mental, or emotional condition, and if necessary, limit, suspend, or terminate their professional activities. If the LPC possesses a bias, disposition, attitude, moral persuasion, or other similar condition that limits his or her ability to recommend a course of treatment or decision making that is indicated, and under such circumstances where all other treatment and decision options are contraindicated, then in that event the LPC shall not undertake to provide counseling and will terminate the counseling relationship in accordance with these rules. The next one is section 186-10-3-2-G, and it talks about if as a counselor or consultant having knowledge of someone that is impaired, and it says if a LPC becomes aware that a LPC or LPC candidate is violating an obligation described in Oklahoma Association of Counseling 86-10-3-2-F or Oklahoma Association of Counseling 86-10-3-4B, or other provision in the Act or this chapter of regulations, the LPC must, within 30 days, report the situation to the board in accordance to the Oklahoma Association of Counseling 86-10-29-3. The report shall contain, at the minimum, the following: the name of the LPC or candidate who is allegedly impaired, any facts that can be revealed concerning the impairment. 4, the LPC shall maintain the confidentiality of the client pursuant to Title 59 of the Oklahoma Statutes, Section 1910, unless a signed release is received from the client. The last question on our says that what is the question this brings to mind? Well, when I was reading the case with Miss S and it being a juvenile facility, the one thing that I wondered was if because he was a juvenile, he was only 16 years old, because the boy was a minor, what role, if any, did the parents play in the counseling session? And if it was because he was sent by a third party, being the court, would that waive any client consent forms that the parent would have to fill out, or if the parent had to fill out any? Well, thank you. Have a wonderful day. God bless you.